Good evening, everyone. Good evening to all of you. For the benefit of the upcoming advocates and the advocates who are still in the profession, I'll repeat the two important, the important sections of the NI Act. That is, first is Section 118 of the NI Act, which talks about the golden presumptions of the Negotiable Instruments Act. These presumptions, please, yesterday someone asked me, sir, is it may or is it shall? I don't know what is the difference between may and shall. May means it's a discretion of the court, but as far as shall means it is mandatory. The court has to follow it, whether it likes it or not. As far as 118 is concerned, which most of our advocates are ignorant of it, they talk about the golden presumptions under the Negotiable Instruments Act. The first one is presumption as to drawer. That is the person who issues the check, or the person who executes a promissory note, or a person who is bound by the bill of exchange. And the drawing next one is as far as there is a presumption that the person who has drawn the check or drawn the promissory note is the drawer himself or the debtor himself. The second one is drawee. As far as the presumption as to drawee means, the person in whose favor the check or the promissory note is executed is called the drawee. And there's a presumption that the person to whom the check has been given or the promissory note has been executed, there is a presumption that it has been executed in favor of the drawee. Third one is time and place. Time and place means where the document has been executed, or what is the place at which, the time at which it has been executed. That is the third presumption. The fourth presumption is presumption as to execution. Presumption as to execution means the NI or the negotiable instrument has been executed by the person whose name is mentioned as the drawer. And next one is presumption as to consideration. Presumption as to consideration means that monetary transaction has taken place between the debtor and the creditor, and there's a presumption that money has passed on. And next one is presumption as to the person who holds the promissory note or the check is a holder in due course. These are the six golden presumptions or seven golden presumptions as far as 118 is concerned. Yesterday, one of the candidates asked me, sir, is it mandatory or is it obligatory? Please remember, the dictionary meaning of may means it is a discretionary one. But here the word that is used is shall presume. Shall presume means it is mandatory, it is not obligatory. So these six golden presumptions have to be kept in mind when you prepare the defense as far as an NI Act is concerned when you appear for the accused. That is what I discussed yesterday. I think Mrs. Anuradha Bakaraju also was not present yesterday when I was dealing with this subject. And the next one is 138 of the NI Act. This is very, very prevalent and feeding most of the advocates today. Please remember, NI Act was taken very, very easily earlier, and it has been made tough now, where I say that because the money flow is required and people should not go back on their promise to pay, or people should not disown their liability on frivolous grounds, this 138 has been enacted. What are the ingredients as far as 138 is concerned? That is, 138 has to be read in conjunction with section 142, which says that there must be a pre-existing, again I repeat, there must be a pre-existing monetary or pecuniary liability between the debtor and the creditor. Unless there is a pre-existing monetary liability, 138 is not attracted. So most of us forget 142. When you draft a complaint or when you give a notice, be very, very careful that you mention towards the pre-existing monetary liability, the debtor has executed a promissory note or given a check. Then once the promissory note or the check is given regarding, please remember, towards the discharge of the debt, that is, towards the discharge of a monetary liability, a check or a promissory note is given. And then, once the check or the promissory note is due for payment or presented for payment, it gets dishonored due to some reason. So, insufficient funds, refer to lawyer, signature differs, signature illegible, account closed, so on and so forth. That is what is called the endorsement made by the banker with whom you deposit the check for encashment. Then the bank memo comes to you, and the bank memo with the endorsement comes to you. Then it is your duty, if you want to come under 138, to issue a notice to the opposite side mentioning all the facts and saying the check has been given towards it. Please remember, and I've underlined the word, the check has been given in discharge of a pre existing monetary liability between the debtor and the creditor. And when the check was presented for payment or encashment, it got bounced due to various reasons. And then 15 days clear notice has to be given to the opposite side to make good the payment. And please remember the date of dishonor, the date when you receive the bank memo is excluded for the purpose of limitation, and the period of limitation starts running from the next day. Suppose the memo comes to you on 15th, then from 16th, 15 days period counts. Then you have to give notice to the debtor to pay the money within 15 days from the date of receipt of the notice. Please remember, yesterday also, I still remember one of the students asked me a question, sir, is it from the date of receipt or date of notice? Please remember, when it comes to the knowledge of the debtor, that is on the day when the notice is received by him, 15 days period is calculated from that day. Why this 15 days period is given is so that the amount is paid and there is no need of approaching the court for redress. Then after that, if no reply is received or no payment is made within 1 month, you can file a complaint before the concerned magistrate who has got jurisdiction over the police station. Please remember, it's absolutely a technical offense. A technical offense in the sense all the mandatory requirements as laid down in 138 and 142 has to be followed. Even a slight mistake on your part will entail in the dismissal of the complaint. Then, after that, when the proceedings are initiated or the proceedings are filed into a competent criminal court, then what the criminal court does is it takes cognizance of the complaint, and along with that, you have to file the sworn statement also. The court takes cognizance of it and takes the sworn statement and then post the case for numbering, and the case is numbered as STCNI. STCNI means summary trial case on the side of the negotiable instrument. And please remember what is the essence of a summary trial, sir. Some of you are practicing. On the criminal side, summary trial means it has to be disposed of within a period of 6 months, and the elaborate trial is not required, and the matter is disposed of accordingly. Then after that, once the sworn statement is accepted by the court, the case is registered as an STCNI, and then summons are issued to the opposite side, and the other side is called upon to be present on the day fixed at the time fixed by the court. And in pursuant to the summons or notice, the accused is bound to attend the court on that particular day at that particular time. And please remember the consequences of not appearing in spite of the summons being served. The NBW, or what is called non-bailable warrant, will be issued by the court to arrest the accused and bring him to court. And one more thing I would like to enlighten you, like civil courts, we don't have the Nazaret, where you get the summons served through the court, through the process of the court. But as far as STCs or criminal cases are concerned, summons are served through the police constable attached to that particular police station. Then, once the accused appears, consequent to the summons being issued to him, The court has got the discretion to ensure his attendance on every date of hearing. It calls upon him to give a personal bond for 5,000 rupees or 10,000 rupees, as the case may be, or may also insist on sureties being furnished as far as the offense is concerned. Then, afterwards, what happens is the question is the trial starts. The trial start. I mean, sorry. Then in that case, what happens is there is a provision in CRPC. Most of you are aware, and I'm talking about the old CRPC, sir. 156.3, where it says you can request the court, sir, an offence has been made out under the Act. Please refer the matter to the police for investigation. Then the police embarks on an investigation and submits a report to the court called IR, or what is called investigation report, under the provisions of section 174 CRPC. The advantage of referring the complaint to the police officer is one thing. You know how the police deal with the person. The police will blackmail, police will threaten, police, because they act at the behest of the complainant, and then they take some admission there saying that the accused will pay the money within a particular date. But courts are very, very reluctant to send it to the police for investigation. For the simple reason is you have, you have to guard yourself against inducement, threat, or promise. Then what happens is once the IR is filed into the court, the trial starts, and the person concerned, who is the complainant, will be examined and then cross-examined by the other side. And then the matter is all the witnesses are examined. And after that, 313 statement also is recorded. 313 statement under the old Act, CRPC, will be recorded. Then after that, defense will be given a right of leading its defense if they have got witnesses to prove and establish their defense. And then after that, the matter is posted for arguments, and arguments are heard, and the judgment is passed accordingly. This is a procedure laid down in section 138, coupled with section 142. But one thing you remember is the it is a summary trial case, and it is triable only by a metropolitan magistrate. Now I think under the new Sanhita, that is whichever Sanhita it is, Bharatiya Nyaya Sanhita, the question is it is triable by a magistrate, judicial first class magistrate. But in our metros, especially Hyderabad and agency area like for Vizag and all, it is tried by the ACM, that is the chief additional chief magistrate, and then it has to be disposed of within a period of 6 months, like any other criminal. And please remember, the powers of the magistrate, as far as STCs are concerned, is only 2 years. A sentence cannot be passed for more than 2 years, and the fine limit, which is fixed, is 5,000 rupees. A magistrate can impose a fine of only up to 5,000 rupees. But what we are finding today is most of the judges on the NII cases are lady judges. And even if, God forbid, if the complainant is absent or the accused is absent, the cost which is imposed by the criminal court is 5,000 rupees cost is being imposed. We have never heard of such cost being imposed by any court, but that is the order of the day today. But anyhow, if the case is disposed of, it leads in either conviction or acquittal. Conviction means he is sentenced, but the acquittal means when the case is not made out, the accused is set at liberty. One thing you must remember is, suppose the question is, it is purely a technical offense, sir. Can you tell me what are the defenses open to an accused? Please remember, most of us, we are not fortunate to appear for the complainant. We appear for the accused. And please remember, the accused pays more fees than what the complainant pays. Why? Because the accused wants to get out as early as possible from a criminal trial. The very fact that he is attending the court on every date of hearing itself is a punishment. Here, the question is, suppose the question is 138 has to be strictly complied with. There is no question of having any laxity. Any mistake on your part, any technical defect on your part entails in the complaint being dismissed. and the period that is mentioned in 138 has to be strictly followed. The question is that's the reason when we draft a complaint under the NA Act, not complaint also the notice which is given, what we do is we follow a tabular form. That is, we say particulars of the check. First, we say name of the drawer, then name of the drawee, number of the check and date, bank on which the check is given, by the accused, name of the bank where the check is presented for encashment, then the place of residence of the accused, place of residence of the complainant, and also the amount covered by the check, and the date of dishonor and the proof of dishonor. These are the basic requirements which we mention in the notice. And when you draft a complaint, it becomes very, very easy for you to draft a complaint because your notice is going to be the verbatim complaint which you are going to lodge in the courts. Even in civil cases, I follow the same procedure. That is, we say the plaintiff relies on the following documents in support of his claim. Then the question arises, sir, whether the complaint has to be drafted with 6 pages or 7 pages or in 2 pages. Please remember the number of pages is not important. Whether you make out the ingredients or not is important. And please remember, you be as brief as possible. You don't get caught anywhere. Then, sir, what are the defenses open to an accused in a complaint under 138? The defenses that are open to the accused is discharge of contract as laid down from section 56 to 63 or 64 of the Contracts Act, doctrine of frustration, doctrine of novation, doctrine of remission, doctrine of alteration, doctrine of modification, so on and so forth. Or in other words, you say that the check has been given not towards the monetary liability, it has been given as a security for performance of the duties on my part. Or next one is you must note sometimes what happens is these creditors are very, very clever. What they do is they tamper with the document. And please remember, there are some figures, if you remember, for example, if you take 2, 1, 2, 2 can be made into 3 by suppose you put a small thing, it can become 13. Suppose 16 is there. 16 you can make it into 8. 6 you can convert into 8. And please remember, when you indulge in material alterations as far as the instrument is concerned, be it a promissory note, be it a bill of exchange, or be it a check, it initiates the complaint and the complaint can be thrown out. And another defense which is open to the accused is, sir, I don't sign in English, I do not know English, I sign always in Urdu only, or I sign only in Telugu, or I sign in Kannada, or I sign in Malayalam, or I sign in some language which I know. I am not acquainted with English. I never sign in English. And even my signature, which is put on the document, is not my signature, it's a forgery. Then these material alterations which are made vitiates the complaint and your complaint can be thrown out. Please remember, nowadays we are in the era of using ballpoint pens. When we use ballpoint pens, see, for example, if you take the word "we," or suppose a person is called as Varalakshmi, the verb "we" is there, alphabet "we" is there, and there is a style of writing "we." Some people use small letters, some people use big letters, and "we" they decorate it also by having a circle, and "a" they put it like this, or they put it ordinary. So to achieve perfection of forgery, I'm not preaching forgery, but to achieve forgery, what they do is they pause at a particular alphabet. Why? Because they want perfection. Here, what happens is, if you see the ballpoint when you press the ballpoint on the paper, it smudges. There is a smudging there. So the question is, the signature is not a genuine signature. It is a forgery. You can send it under section 45 to the handwriting expert to find out whether the signature pertains to the person or not, or whether it's a forgery. Here, I would like to deal with the what is called IPC. In IPC, there are 3 or 4 sections which deal with forgery. There are two types of forgery which is practiced, sir. That is, I think if I'm correct, it's 467, 468, 469, 470, 471. There are two styles, two methods of forgery. One is called the tracing method, and other is called the freelance method. Tracing method is you take a tracing paper, and suppose my admin, Mr. Kalyan, writes, I know his signature. I put a tracing paper on his handwriting, including his signature, and take a verbatim copying of his signature, including the manuscript. Then, when I get that copy, it looks like a genuine copy. That is called the tracing method. That's the easiest if you ask me. Then another type of method is freelance method. What do you mean, Madam Operation? Just follow. Freelance method means where there are two styles of writing, sir. Especially if you see ladies who write, they put their finger very close to the tip and they write. Because with due respect to the ladies who are attending the lecture, they suffer from what is called insecurity. So the question is, they put it very, very close and then write. And when they write, the strokes which come out are small strokes. But please remember, male always feels superior. He puts his holding the pen here and then writes. When he writes, what happens is the strokes which come out are big strokes. And the question is, from that you can make out the style of writing, whether it's a female or a male. Then after that, there are some distinction. That is where there, as far as the strokes are, please remember, sometimes when we get old, please remember we are not going to remain young always. We are not going to be sweet 16 always. When we advance by age, we develop a shake in our hands, and our signature will not be that legible or that clear as it was when we were young. So the question is, there is a shake as far as the signature is concerned. But I this freelance method is very, very difficult to follow. Why? Because I have to observe a person for a long time and try to copy his handwriting, try to copy his signature, the style of writing, the style of strokes, the style in which he puts his signature, whether he is an artist. Please remember, artists have got a tendency of decorating every alphabet. And he is an artist, that person has signed. I copy his signature, I copy his handwriting, so on and so forth by long observation. That is what is called freelance method. That is mastered by long usage. That's why try till you succeed. That's what they say. But please remember, a thief leaves a clue somewhere or the other. That is, in Urdu they call it a surag. That is, the question is, you can always catch him. That means, as an advocate for the defense, as an advocate for the accused, you have to examine. Please remember, don't try to be over enthusiastic and say that you want to make an impression before the other advocate sitting by saying, "Sir, are you ready for cross examination?" "Yes, sir, I'm ready." You don't think that the judge is going to be impressed by the question, or you try to make out a impression that the other advocate sitting will be thinking, "Are what clever advocate this man is. On the first date of hearing itself is ready for cross examination." Please remember, cross examination is an art, cross examination is a science, cross examination is a proper technique. It comes by experience and not by reading books. So the question is, examine the document, examine the notice which is given, examine the date when it has been received, and try to find out from your client whether there has been any innovation, whether there has been any doctrine of frustration, or whether there has been any remission, whether there has been any variance, or whether there has been any alteration in the terms of the contract. And then, whatever defenses are open to you under the Contract Act, you try to use your brains and then use it as far as your case is concerned. What I'm trying to tell you is, material alterations of a negotiable instrument vitiates the complaint, and that you can easily find out by you are using your brain or using your IQ. Please remember, be very, very attentive, especially when you appear for an accused. After all, when the complainant comes into the witness box, he will only speak blah, blah, blah. Whatever is stated in the complaint, he'll just repeat like a parrot. But as far as you cross examine him, try to find out these loopholes, try to find out the defects, try to find out all these things before you cross examine. Please remember, though you take some time, prepare your cross examination well, and don't raise your hands and say, after all, check has been given, after all, promissory note has been executed, after all, 118 Act is there, presumption is there regarding execution, presumption is there regarding consideration. Presumption is also that the person holding the instrument is a holder in due course, and so on and so forth. Please remember, if you take the trouble of going through the document, going through the notice, going through the reply, going through the various defects in the complaint, please remember sometimes what happens is this. I've seen in one of the cases of my colleague, the check is dated someday, and the complaint, it is mentioned that check was given on a particular date. There is a variance between the instrument as well as the complaint. You can definitely take it as an inconsistency or a contradiction or an omission, which you can take advantage of, and which where you can succeed to get your client acquitted. Your motive should be to get your client acquitted because he has come to you with trust and confidence, testing your knowledge, testing your skill, testing your integrity, and testing your expertise as far as cross-examination is concerned. So cross-examination plays a very important part in this type of technical offense. And 313 statement also, when the accused is put into the witness box to examine him as far as the statements are concerned, you tutor your witness, tutor your accused in such a way to say, sir, there is material alteration, there is a forgery, so on and so forth. Whatever defense you could lead, try to get it out of the mouth of the accused. So these are all the formalities as far as 138 is concerned. It is in Telugu, it is not like Oche Kotte Teche. That means everything has to be gone into in detail, in minute details, and it also has to be up to the point and up to the take advantage. Suppose the notice is defective, it does not say that the check was given in consequence of a pre-existing monetary liability as embodied in 142 of the NI Act. The complaint is likely to be thrown out. One more instance I'll tell you, sir. The question is, suppose instead of giving the notice to the husband, notice is given to the wife. Is it a proper notice? No. Why? Because the person who has drawn the check, the person who has given the check, the person who has executed the promissory note is the husband. Wife is no way concerned with that. Suppose you give a notice to a wrong person, then the case will not stand. I again give a mythological example, sir. Here, as far as we Hindus are concerned, we say once the husband and wife when a man and woman get married, they become one, and the husband and wife were all alone earlier. They become a farm covert. That means a married person, or a yoke is put on the head of the wife to say that till now we were all alone. Now we are going to plow the field called the samsara, and we are going to live together in times of plenty, in times of happiness, in times of nothing, in times of loss, in times of so on, so on, so on, so. That is why Saptapati is performed. But when it comes to the property issue, the question is, what you say is husband is different, wife is different. There is a contradiction as far as our Hindus are concerned. But in England, the question is, as far as wife's debts are concerned, husband's property can be proceeded against, and husband's debts are concerned, wife's property can be proceeded. That is the position in England. But in India, husband's property is different and wife's property is different. The question is, though we call the husband as a Ardhanarishwara, no question of Ardhanarishwara, is only a Ishwara, that's all. Nari is not there. So properties are different. So these are all the defenses which can be made use of while conducting a defense in a case of NI Act. Are you able to understand, please? Then we go to section 139. Once you go to 139, the question is only in Chennai, they say 139 provides for what is called when the court decides to convict an accused, the court has got the power to collect double the amount as compensation. One part of it, the check amount, goes to the complainant as compensation, and the other half goes to the state by way of fine. But please remember, this is followed only in Chennai. But as far as our state is concerned, we don't follow section 139. Then we go to new sections which have been included in the NI Act by the Amending Act of 2018. That is section 143 to 149 of the NI Act. 143 speaks about when the accused is acquitted of the offense under the NI Act, whatever amount he has paid towards interim compensation, that amount has to be returned by the complainant to the accused within 60 days from the date of order. Then 143A, also a section which was incorporated, which says that 143A speaks about, it's called uh, 143A, please remember sometimes, though it's a summary trial, we as advocates know that it is only on paper, but it is not disposed of within 6 months. You can remember once the money gets held up, money gets locked, how much of difficulty the creditor will face. That is the reason a provision has been made under 143A. Even during the pendency of the proceeding, court can grant interim compensation. Interim compensation can be paid, can be allowed as far as the complainant is concerned. Only condition is subject to 143. It says if the accused is acquitted and the case is dismissed, whatever amount is paid towards the interim compensation has to be returned back by the complainant to the accused within a period of 60 days. Then we go to 144. 144 deals with what is called why this provision is made, sir? This provision is made so that parties may not delay the matter. Parties will go on with the matter in a speedy way, and it is disposed of within the time frame. Then the question 144 deals with what is called, it is almost parallel to your Order 5 Civil Procedure Code. It says where the summons have to be served. The summons have to be served on the accused where, sir? At his residence or its place of office. That's what 144 says. Then 145 speaks. Please remember, for the first time, 145 has been brought into existence, minimizing the time of the court. Like your Order 18, Rule 4 and 5 CPC, evidence affidavits can be filed in lieu of being examined in court, that is, in lieu of examination in chief. So 145 gives the power to the court to receive evidence affidavits, that is, chief examination, in lieu of chief examination recorded in the court. Then 146 is production of bank slip with official seal of the bank is prima facie proof of dishonor. Please remember, I think bank doesn't receive the amount cash on hand, but what it does is it expects you to fill up a slip called the pay slip. In the pay slip, you mention the check, you mention the bank on which it is drawn, you mention the date on which it is drawn, and the amount which is covered by the check also you mention in the pay slip. Filing that pay slip with the bank endorsement and the seal of the bank is prima facie proof that the instrument has been dishonored, or the bank memo which you receive from the bank saying that the check which has been presented for encashment has been dishonored. Then we go to what is called unless rebutted, of course. 147. Here, I think most of you are aware that there is a provision in CRPC called 320 CRPC. That 320 CRPC deals with what is called compoundable offenses. Compoundable offenses is, that is, with the permission of the court, the respective charges made or the counter charges made can be settled without the intervention of court. That is what is called compounding of offenses. And most of the compounding takes place in the court itself, or it's referred to the Lok Adalat, and it's settled across the table. But please remember, even 498A, most of you know, under IPC, which was a cruelty to women, I think that is a section of 498A. Even 498A today can be compounded, can be settled out of court, and the court can excuse the accused of liability. And the same provision has been incorporated in the NI Act by way of section 148. I'm sorry, 147, sorry, sir. Then next one is 148. Suppose, let us say, the accused is convicted of the offense under the NI Act, he definitely goes by way of an appeal. Like in civil courts, when you file an appeal, you also ask for stay or you also ask for suspension. You can definitely ask for suspension of the offense, suspension of imprisonment, but the fine amount which you have to pay as per the order of conviction, you have to deposit it in the court. And the 20% of the check amount has to be deposited by way of security if you want to get suspension under 148. Then 149 and 150, sir, deals with definition of NI. That means NI, negotiable instrument, means and includes only promissory note, bill of exchange, and check. So that is as far as the new provisions which have been incorporated or introduced by the Amending Act of 2018. So whatever deficiencies were there, whatever defects were there earlier, now has been supplemented by these new provisions. Of course, I have gone on record by writing a letter to the law commission. Sir, why don't you introduce a section saying that when a complaint is filed under the NA Act, like Consumer Protection Act or other acts, question is execution also is provided in the same court. Why don't you introduce a provision to say that once a complaint is filed, it ends in what is called, let us say, complaint is filed. You must ask the complainant to pay half the court fee that is provided in the Court Fees Act, so that the party may not go to the civil court and file a parallel proceeding under the Civil Act. Why I'm telling you this is, I think 2 days back, you got a latest judgment of Karnataka High Court. I think it was given by Justice Naga Prasanna, who said you cannot ride two horses at the same time. You cannot file a criminal complaint under the NI Act or any criminal act and also file a civil suit. You choose either one of them. You cannot ride two horses at the same time. That is what the judgment of Justice Naga Prasanna is concerned, of Karnataka High Court. This came about 2 days back. Then one more judgment which I would like to enlighten you is the judgment rendered by Justice Sesha Saina Reddy, who was asked to decide a case as far as the jurisdiction part of it is concerned. Madam, 1 minute. So, as far as jurisdiction is concerned, I was told that Justice Sesha Saina Reddy belongs to Nandyala, Guntur district. And this man gave a judgment saying that, commenting about jurisdiction, saying that the complaint under the NA Act has to be filed at the place where the accused resides, and the accused cannot be compelled to come to Hyderabad or some other place to face the charge. Of course, this matter was canvassed again in the Supreme Court. The Supreme Court gave about 5 or 6 options where the complaint can be filed. One is place of the complainant, place of the accused, name of the place of the bank where the check is issued, place of the bank where the check is sent for encashment, place of the bank which has issued the bank memo, and so and the question is the place of residence of the accused, place of residence of the complainant. All the 6 factors, any one of them you can choose and file the complaint. So the question is, now the net has been widened, and Sesha Saina Reddy's judgment, because this man belonged to Palnadu, that is Guntur district, he gave a judgment where they say, suppose the accused is from Guntur, you will have to file the complaint in Guntur alone, not in Hyderabad. But Supreme Court gave us 6 or 7 options, whereby they say place of the accused, place of the complainant, place of the complainant's residence, place of the accused residence, place of the bank on which the check has been given, the name of the bank where the check has been sent for encashment, bank which has issued the bank memo, so on and so forth. Any one of the options you can definitely follow. But please remember, when you draft the complaint, especially the jurisdiction paragraph, you have to be very, very careful to say that you come under any one of the options. So I would just put it in short, Justice Sesha Saina Reddy's judgment is no longer a good law. Then we come to the inconsistencies and contradictions and the varied judgments of the Supreme Court. When Justice K.T. Thomas was there in the Supreme Court, he was asked to interpret what are the consequences when 2 notices are given regarding the check bouncing. What Justice K.T. Thomas said is, only you can give 1 notice, but you cannot give 2 notices. If a case is founded on the 2 notices, the complaint has to fail, and there's no question of giving 2 notices. Even K.T. Thomas's judgment today has not been overruled till today. It holds a good law today. So please remember, you have to study the case, study the defense, study the attack from various facets, and then prepare your defense accordingly. Of course, what I learned from my senior, who was my own father, he said, Sir, after all, you know what is the crux of the complaint. You know what is the crux of your defense. You prepare a questionnaire beforehand and then try to cross-examine a witness. You don't falter anywhere. Don't feel shy of preparing a questionnaire, because sometimes what happens is no one is gifted with infallible memory. Sometimes your memory fails also. That is the reason, to be on the right spot, you prepare your questionnaire beforehand. So this is as far as the 138, 139, 142, new sections 143 to 149 or 150 of the NA Act. Then again, yesterday I dealt with the small sections up to section 32, 33, because I wanted to deal with these provisions, because my colleagues are also there in the profession. They are new entrants and they've got 3 or 4 years of experience. But please remember, these are all the technical aspects which I wanted to share it with you. Though I don't appear in NI Act cases, I hand over the matters to my juniors to hand over with proper instructions. But this is what I learned from the experience. Then we go to section 33, which deals with what is called only drawee can accept except in need for honor. See, in bill of exchange, sir, what happens is the business is not rosy all the time. No doubt the seller, because of confidence and trust which he has on the purchaser, he delivers the goods. Please remember, no one in business delivers anything free of cost. Then let us say our buyer has got one common friend of seller and buyer, who is a third person. Here, the buyer, that is the debtor, authorizes a third person to pay the debt due under the promissory note, due under the bill of exchange, or due under the check to the seller concerned, because the goods have already been delivered and the credit has been given for 3 months to make the payment. Then the third party, on behalf of the drawer or the debtor, makes the payment to the drawee, and the drawee's claim is satisfied to the extent of the goods supplied. Then, sir, it is said that the third person who has paid the money, or let us say the seller who has accepted it, the question is, when a drawee for honor makes the payment, then in that case it has to be accepted only by him, and he has to be compensated for the amount for which has been paid. Then 34 is acceptance of several drawees, not partners. Please remember, what is the essence of a partnership, sir? How is partnership defined? Partnership is defined as, if you see the Partnership Act, unfortunately, the Partnership Act does not define a partnership properly. What does it define, sir? It says partnership, a firm is a firm which comes into existence, and the partners come together in order to share the profits of a business, right? That is the definition given in your Partnership Act. But to have a lucid interpretation of the definition of partnership, it means where two or more persons come together, pool up the resources, and build up a foundation called the capital on which the business rests, and then build up the superstructure called the business, and with the ultimate object of running the business and churning out profits and then distributing it amongst the partners. And the liability of a partner, is joint and several. Every partner is an agent of the other. Every partner is a trustee of the other. As far as the debts that are incurred or liabilities that are incurred by the firm, all the partners are jointly and severally liable, so on and so forth. So the question is acceptance of several drawees not partners. Suppose they are not partners at all, several people have accepted it, then in that case it has no validity at all. Then liability of endorser. Liability of endorser means, I told you, the definition of negotiable instrument means it is easily transferable. How many parties are there as far as negotiation is concerned? It is the endorser, the person who makes over the document, or the person who receives it or accepts it is called the endorsee, and the transaction is called an endorsement. Here it is said liability of the endorser. Liability of the endorser is when he fills up the endorsement, he has to fill it up properly, and he should also make it known that so and so is going to be your debtor. You have to receive the money from him, and he has to put his signature and put the date of endorsement, and then give a notice to the debtor that the NI has been endorsed in favor of C, and in future all the amounts will have to be paid to the endorsee alone. So if he does not do it, the endorser is also liable. Then liability of prior parties to order in due course. Here also, who are the prior parties? That is, the debtor is also liable to the liable to the holder in due course. That means, suppose I got the instrument by way of endorsement, by way of negotiation, then the question is the prior parties who are there, that is creditor and debtor, they are liable to me. Then maker, drawer, and acceptor principles. That is here. Suppose let us say the document is executed by an agent on behalf of his principal, so long as the agency business is in oak and the agent acts within the four corners of the agency business, then whatever acts are done by the agent for and on behalf of the principal binds the principal also. The question is maker, drawer, and acceptor and principals are liable. Then next one is prior party or principal in respect of each subsequent party. Of course, all these things are they are all of academic interest. They are not very, very important. Then suretyship. Suppose a surety document has been executed, the surety, along with the principal debtor, is jointly and severally liable for the debt to the creditor. I think with this we shall stop. We have stopped up to section 39, and rest of it we'll deal with it in the next class. Because my importance was to repeat the consequences of 138 to 149, 150, and then the golden presumptions of Negotiable Instruments Act. And I think some of you know have knowledge of banking, know there's a difference between two types of checks. One is called a bearer check, and another is called a cross check. As far as a bearer check is concerned, anyone can draw the check if they find it on the road, and only it is not necessary that only the person whose name is mentioned has to draw it. So we have to be very, very careful in issuing bearer checks. But as far as cross checks or account paying checks are concerned, it can be drawn only by the person in whose favor it has been given, and it is crossed with two lines and co is mentioned. That means he has to present it for encashment and will be not paid across the counter. So we have finished up to section 39, along with section 118 and 138 to 150 of the NI Act. The rest of it are all consequential sections which has to be taken only for academic purposes, and I will try to deal with from section 40 up to the end in the next two classes. I think it will take about 2 to 3 classes more to complete NI Act. Thank you.
Interaction session starts now. Please go ahead with your questions if you have it. Any questions? All right, I hope so. Everybody is not having any questions. If you have any questions, please raise your hands and let us know. Mr. Vasant Rao, please go ahead. Madam, hello, Jane. You can go. You can unmute yourself and go ahead with your questions.
Sir, this is Venkatesh here, sir. Sir, with respect to latest Supreme Court, where the place of where the accused resided and the place of the complainant or accused. Yes. So you have told 6 points, right?
Yes.
So can you please repeat that?
Yes, sir. That is place of the accused residence, place of the complainant's residence, the place where the bank check has been given by the lawyer, place of the bank where the check has been sent for encashment. Then next one is the question is these are the 4 options that are given, 4 or 5 options that are given. That is, the first one is place of the lawyer, then there is a residence of the lawyer, that is the debtor, then residence of the creditor. Then next one is bank on which the accused gave the check, bank on which the check has been sent for encashment by the drawee, and then the question is the residence and the office, so on and so forth. They are the places, any one of the places you can file a complaint. There's absolutely no hard and fast rule that you must file it only at the place where the accused resides. Sir, are you able to follow, please? That is Justice Sesha Saina Reddy's judgment has been negated by the Supreme Court judgment, sir.
Shesha Saina Reddy judgment, sir.
Yes, sir. Justice O. Sesha Saina Reddy of the composite Andhra Pradesh High Court.
Okay, sir.
Sir, good evening, sir.
Yes.
Sir, good evening.
Yes, Mr. Vasantarao.
Good evening, sir. Sir, I heard that issuing multiple notices before filing complaint
Yes.
is maintainable. In a Supreme Court judgment I saw, but right now I have not about that judgment. But issuing multiple notices, 2 or 3 notices before filing the complaint is also not is maintained.
That's what Justice K.T. Thomas's judgment was there earlier. 2 notices cannot be given as far as NI Act is concerned.
Now that was overruled that issuing 2 notices are
Sir,
also not in the
if you see the judgments of Justice K.T. Thomas of the Supreme Court, it was full of inconsistencies, which has been negated by the subsequent judgments of the Supreme Court. But it's absolutely absurd, sir. Can't you give a notice again?
Of course, sir, but in some case I heard that right now I have no remember the statement.
I'll just check up, sir, because I told you earlier itself that I asked my colleagues to go on with NI cases because I feel it's too small for me. And another thing is I give them proper instructions to go on. Please remember, don't think that because you're appearing for the accused, there are no defenses. If you see the Contracts Act carefully, from section 56 to 62 or 63, there are various defenses which are open, like novation, recession, remission, alteration, variation, frustration, so on and so forth. But the question is, you have to go through that. Unless you go, and another thing is, the question is Companies Act. Suppose you take the Companies Act, the promoters enter to pre-incorporation contracts, enter into debt liability also. The question is, after the company is born, whatever debts are incurred by the promoters and they become the first-time directors, they are approved and resolved on the first meeting, and the debts or the pre-existing liabilities survive. And amalgamation also, suppose 2 companies come together, whatever liabilities are there before the company which was merged, the succeeding amalgamated company is bound to discharge that liability, sir. And please remember,
Sir,
when you file a complaint against the company, you have to bring it in the corporate name. Directors are not personally liable, sir. Please bear that in mind.
sir,
But
another
as
doubt, sir, not
no, directors are not personally liable for the debts of the company. But as far as the firm is concerned, joint and several liabilities there. Any partner can be made liable.
okay, sir. Thank you, sir. Another doubt, sir.
Yes.
Sir, this is not regarding to the NI Act. This is some other things regarding to the bill, sir.
Will.
Sir, bill.
Yes.
Sir, the still was the return on a bill, but he didn't mention that the bill will come into force after my death. Only that part of the scene.
Even if it's not made, it does not vitiate the will, because will is supposed to be a testamentary transfer. Like other non-testamentary transfers like sale deed, gift deed, and all, which comes into effect immediately, will comes into effect only after the demise. But the question is, normally we are supposed to write, this will is my last will and comes into effect immediately after my demise, and I reserve my right to cancel or vary the will anytime during the lifetime.
Only submission, sir. Only the thing missed is the will come in after my demise.
Yes,
Only that one.
even if it's missing, it's not going to have any disastrous effect.
Court has to different you. They became say conveyance, not bill.
No, it cannot be taken as conveyance. Will comes into effect only after the demise, not otherwise. Even if it's not mentioned, it is understood that it comes into effect only after the demise. That's what it's called testamentary transfer. And one thing you must remember, as far as a Christian will is concerned, Christian will has to be compulsory registered and letters of administration or probate has to be obtained. And if you take the case of a Hindu will also, suppose an executor is appointed to implement the will, the question is probate has to be obtained. But as far as Hindus are concerned, probate is not mandatory under Section 50 of the Indian Succession Act.
Sir, one thing, sir, I filed a OP for issue of letters of administration.
Yes.
But what was refused that this court is not, there is no necessary to issue letters of administration. Then what is the problem is one son is, one grandson is get the will, the other sons are objecting that.
Yes.
How in that situation, what I have to do?
The will has to be proved by examining the attestat,
By filing the
by
declaration.
examining one of the witnesses who has signed or countersigned it as having witnessed the signature of the testator or the testatrix, or if she is a Pardanishin woman, to come and testify that the contents of the will was read out to the Pardanishin woman who was behind the parda. She was properly identified and she admitted the contents thereon. So examination of one attestat is absolutely mandatory as far as proving a will is concerned.
This has to be filed, this has to be get filing a declaration of that will.
Not necessary, sir. You can examine one attestat to prove the signature or prove the what is called execution of the will by saying that the person is acquainted with the signature or the handwriting of the person concerned. A question of handwriting comes, it is called a holoclast. When a person writes it with his own hand, it is called a holoclast. It's not called a will. Holoclast means when it is in his own handwriting, the person should, the attestat should identify the handwriting of the person, signature of the person, and the circumstances under which he can identify, and the close acquaintance which he has got with the testator or the testatrix. And the question is, he says, testator or testatrix has signed, and after they sign, I countersigned it in proof of having witnessed the execution, sir.
Okay, sir. Thank you.
Welcome.
Anything
Good evening,
else?
sir.
Yes, Anuradha.
Good evening, sir. This is Anuradha.
Yes.
I'm really thankful and express my gratitude to you for having repeated yesterday's.
I repeated
Section.
it for the benefit of you and my colleague, Mr. Srimati Varalakshmi.
Thank you so much, sir.
Yeah.
Thank you.
Yes, next.
Sir,
Yes,
sir,
yes.
sir, is it audible?
Yes,
Yeah,
sir. Tell me,
you're
sir.
audible.
Sir, in the NI Act, the check is presented
Yes.
one time.
Yeah.
Second time also he has presented.
Right.
How many times the check shall
Check
be
can be
presented?
presented as many times as possible within the period of 3 months.
Within the period of 3 months.
3 months.
Okay, sir. And in that case, once check is dishonored,
Yes.
first time within the 30 days, the legal notice
No, within
had
15
been
days.
served.
Within 15 days.
15 days, the legal notice had been served already.
Right.
First time.
Right.
But the accused came and approached the complainant,
Yeah.
decided that matter, and he requested to get that some more time.
Right.
He sought the time.
Yes.
Then he agreed that, but by that time also he did not pay that and did not deposit any amount in such a account.
Right.
Then second time he got issued the legal notice to
Who
the accused.
accused, yes.
Is it maintainable? Then
No.
in the complaint we have mentioned these things also.
If you have mentioned it, even if the accused gives a reply, the question is whether he has made the payment or not, whether there's a relationship of debtor and creditor or not, whether there's a monetary liability or not, or whether the check was given for honoring the monetary liability or not. All these factors you can definitely allege and prove and establish as a complainant.
No, that you said no, sir. That two times we should not.
Not necessary, sir. You have given it, forget about it. You only filed that last complaint, last notice which you have given.
Yeah.
That's all.
On that one only we filed that complaint.
Yes, sir.
Is it maintainable?
And please bear one thing in mind, sir. By just filing a complaint under the NI Act doesn't extend the period of limitation as far as the civil liability is concerned. Civil liability, once time begins to run, it does not stop. That is section 12 or 13 of the Limitation Act. But normally people file a civil case as well as a criminal complaint. But yesterday or day before judgment of Karnataka High Court is, You cannot ride two horses at the same time. You cannot file a civil case for the same liability and a criminal case for the same liability. Either you must choose either a criminal case or a civil case.
No.
I think
Either the civil or
criminal. And a criminal offense in a case or that check bouncing case was dismissed by the court, quashed by the Karnataka High Court. That 2 days back it came. The judgment had come 2 days back. That person who gave the judgment was the sister of another judge. That is she is the daughter of the Supreme Court judge. That is Justice E.S. Venkatramaya.
That we are keeping in our mind that the multiple notices shall not be served
Multiple
to
notices, but after that, my knowledge goes, Justice K.T. Thomas's judgment was also varied. Because the question is, but the check got a life only for 3 months. And please remember one more thing: a conviction in a criminal court will not strengthen your case in a civil court. A judgment of the criminal court is not binding on the civil court.
Okay, thank you.
Thank you, one and all.
Sir, there is a material alteration in the promissory note. Say, for example, 6,000 amount has been made to 8,000. The accuser found out that, and he says that 6,000 has been made to 8,000.
Yes.
Then what happens to the instrument? Whether it is valid for 6,000 or entire instrument?
No question of valid. The entire instrument goes.
Okay, sir.
Yeah. But that you have to be careful, sir. Sometimes we may have to use the magnifying glass also to find out the alteration.
Okay, sir. Okay.
Any questions more? Actually, can we wind up for today? All right. Thank you very much.
Thank you, sir.
Thank you.